Good afternoon, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law number 2. You have been asked to come to court this afternoon, excuse me, for a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felonies and misdemeanor. Your felony cases are normally referred to as your more serious type offenses, whereas your misdemeanor cases are normally referred to as your petty offenses. Does not mean that they're not serious. It just means that they're not as serious as a felony case. Now, when I use the term serious, what I'm talking about the possible punishment that a person can receive if they are convicted. And I'm talking also about the facts of the case. Now, felony cases are handled in our district courts. This is a county court at law, so we handle misdemeanor cases. Now, felony cases are divided into 5 categories. You have the capital murder, the first-degree felony, second-degree felony, third-degree felony, and state jail felony. And misdemeanor cases are divided into 3 categories. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. Now, you have been asked to come to court today for inclusion on a jury trial hearing a misdemeanor case. Our courtroom hours normally vary. They are normally from 8 a.m. in the morning to 5 p.m. in the afternoon. However, in this court, in our morning session, we have other matters such as we have what we call a announcement docket, and then we have a pretrial conference docket, and then we have a trial docket. And what a docket is basically a list of cases that are set that day. And on the average, we usually have about 60 cases usually set in the morning. And so therefore, we have our jury trials in the afternoon, starting at 1:30. Whether you are selected as a juror today or not, you are performing a significant service which only free people can perform. If you are selected, this case will be tried expeditiously, consistent with justice, which require a careful and correct trial. If selected on the jury, unless otherwise instructed, you will be permitted to separate yourself for meals, for recess, and at night. Now, before we go any further, I must take care of an administrative matter. That is, I must administer to you the first of 2 oaths. So I need each and every one of you to raise your right hand. And once I finish administering the oath, please say, "I do." Do each of you solemnly swear or affirm that you will make true answers to such questions as may be propounded to you by the court or under its directions touching your service and qualifications as a juror, so help you God? Please say, "I do." Okay, you may put your hands down. The law requires that each of you must possess certain qualifications before you may be considered as a juror in this case. Also, there are certain excuses and exemptions some of you may wish to claim. First, I would like to determine if all of you possess the qualifications for service on this criminal jury trial. It is very important that you answer these questions truthfully. If you do not, and the lawyers or I discover this fact after you have been seated on a jury, the case could be retried. and you may be held in contempt of court. That is, you can be placed in jail up to 180 days, which is 6 months, and you could be given a fine that does not exceed $500. Now, the way I'm going to ask the questions, I'm going to ask a series of questions. I do not want you to answer those questions out aloud. Just answer the question to yourself. And once I finish asking the last question, I will then ask, is anyone disqualified under the law? And if you think that you may be disqualified under the law, we're going to ask that you raise your hand, your right hand, and then we will ask that you will come up before the bench. This is the bench, so that we can discuss the matter more privately. Now, when I use the term more privately, what I'm talking about currently, we are airing on YouTube. Okay? And so what I'll do, we'll turn the YouTube off, and then I'll turn this microphone off so you wouldn't be able to hear. And then we have what is called a noise sound device. It sounds like this. And once I do that, then we'll have you come up right here on the left side of the bench, and then we'll discuss the matter more privately. So again, I'm going to ask a series of questions. Please do not answer those questions out aloud. Just answer the question to yourself. And once I finish asking the last question, I will then ask, is anyone disqualified under the law? If you think you may be disqualified under the law, just raise your hand, and then we will ask you to come up to the bench. Okay. First question. Except for failure to register, or you're a qualified voter in Jefferson County and the state of Texas under the laws and Constitution of the state of Texas. Have you ever been convicted of theft or any felony? Are you under indictment or legal accusation or on deferred adjudication for theft or any felony? Now, I always pause when I get to this question. I just need to inform you that I'm not trying to pry into your personal affairs. I'm required by law to ask the question. And the question is as follows. Are you presently insane, or have you been declared insane by any mental health or judicial official? Are you 18 years of age or older? Are you a citizen of the United States? Are you a resident of Texas and a resident of Jefferson County? Are you of sound mind and good moral character? Are you able to read and write the English language? And this is the last question. Have you served as a petit juror for 6 days in the preceding 3 months in a county court, or 6 days in the preceding 6 months in a district court? Is anyone disqualified under the law? If you think you may be disqualified, please raise your right hand. Let the record reflect that no one on the panel is disqualified. And so therefore, we will move on to exemptions. Now I will determine if anyone who is otherwise qualified to be a juror wishes to claim one of the following exemptions. You may claim any of the following exemptions if you choose to, but you are not required to claim them. If one of these applies to you, but you still desire to be considered as a juror, just continue to remain seated. Now, I will ask these questions in the same manner that I asked the previous set of questions. That is, I will ask a series of questions. Please do not answer the question out aloud. And once I finish asking the last question, I will then ask if there's anyone on the panel who would like to claim an exemption. First question. Are you over 75 years of age? Do you have legal custody of a child or children under the age of 12 years? And jury service would necessitate leaving the child or children without adequate supervision. Are you a student in a public or private secondary school? Are you enrolled in and in actual attendance at an institution of higher education? Are you an officer or an employee of the Senate, the House of Representatives, or any department, commission, board, office, or other agency in the legislative branch of state government? Have you served as a petty juror in Jefferson County during the past 3 years? Are you the primary caretaker of a person who is an invalid, unable to care for himself or herself? And this is the last question. Are you a member of the United States military forces, serving on active duty and deployed to a location away from your home station and out of Jefferson County, your county of residence? Is there anyone on the panel who would like to claim an exemption? Okay, let the record reflect that we have two people. We have juror number 5 and who's the other? Juror number 8. Okay, juror number 5, would you please come forward? That's Miss Lucas. You come on out. State and defense. Okay. At this time, we'll move on to excuses. Now, with the excuses, I'm not going to ask a series of questions. I'll make three statements. And if one of these applies to you, and if you desire to claim an excuse based on one of the three statements, then we'll ask that you come up before the bench. And the first statement is, a juror may be excused for observance of a religious holiday upon completing an affidavit as required by the Texas Code of Criminal Procedure, Article 29.012C. Next statement. A juror may not be excused for economic reasons without the consent of the parties, that is, without the consent of the state or without the consent, and without the consent of the defense. And this is the final statement. A juror who, without prompting, articulates an inability to listen to testimony and be fair and impartial may be excused. Is there anyone on the panel who will be claiming an excuse? Let the record reflect that no one else on the panel is claiming an excuse. No one else is claiming an exemption, and all members of the panel are qualified. Let the record reflect that the time is 2:21 p.m. on today's date of August 17th, 2026. Let the record reflect that the defendant is present, defendant counsel, counsel for the state, and all members of the jury panel are present. Again, ladies and gentlemen of the jury panel, you have been asked to come to court today to serve as a prospective juror in a criminal case. The cause number is cause number 25CCCR 1758, and the case is styled the State of Texas versus Joshua Dwayne Simon. The defendant, Mr. Simon, is represented by his attorney, Attorney Kevin Lane. The state is represented in this case by Attorney Fred Verner, who's sitting first chair, and Attorney Nicholas Jeter, who is sitting second chair. The court reporter in this case is sitting to my left, and his name is Mr. Sebastian Aguilar. He will be taking down everything being said, so speak up when you're answering or asking questions. The bailiff in this case is Miss Brenda Mosby, and you met her earlier. And the gentleman that's sitting in the jury box is Assistant Criminal District Attorney, Attorney Andrew Hubel. Yes, ma'am. The defendant, Mr. Joshua Dwayne Simon, hold on a minute. The defendant in this case, Mr. Joshua Dwayne Simon, stands charged by information with the misdemeanor offense of terroristic threat causing fear or imminent serious bodily injury. And this is a Class B misdemeanor. The state and the defendant, through their attorneys, have the right to direct questions to each of you concerning your qualifications, background, experiences, and attitudes. In questioning you, they are not meddling into your personal affairs, but are trying to select fair and impartial jurors to hear and decide this particular case. If at any time you would prefer not to answer certain questions in the presence of the panel, just say so, and I will ask you to come up to the bench so that we may discuss the matter more privately. And gentlemen, is 30 minutes enough for each side?
Yes, sir. It is for defense.
Okay. State, are you ready?
Yes, Your Honor, state is ready.
And Mr. Vernon, you may proceed.
Thank you, Judge.
You are. I'll be keeping time.
One. I tend to use the podium. I like to use the front with some few of the folks who get to know each other. And again, as the judge mentioned earlier, my name is Greg, and my colleague here is Mr. Jeter. So on behalf of myself and Mr. Jeter, we're representing the community, Jefferson County, we represent the state of Texas. And so I welcome you to TC2 and Board Diary. So I'll begin the question. What is Board Diary? What's it like? So I like to think of it as a first date. I'm gonna get to know you and ask you a lot of questions over the next 30 minutes, but you're under oath. You can't leave. Nobody gets a second date. But seriously, Board Diary, what does it mean? Board Diary is a French word, and that French word means to speak the truth. To speak the truth. So when there's a trial, it's simply a goal, a push to find the truth of the matter. What's going on? How to resolve this truthfully and fairly. And so today, we're going to pick the 6 people with one alternative to figure out, to figure who that is. Then we'll take your place there, and you will decide the truth of the matter. But today, we want to make a selection. So I'm going to share some things with you about myself. And I ask that you share some things with me about yourself so that we can get to know each other and we can speak truth to one another. That's the only way to be able to do it. So I ask that you speak truthfully to me, share your opinions, your thoughts, your feelings, and I'll do the same with you. So you merely raise your hand and have any question you have about the law or the proceeding, or any question you have about what I'm asking that you go through. So relax. Is everyone okay if I call them by their first name? So how does Board Diary work? Some people call it jury selection. I like to call it jury deselection. Each side gets 3 releases. They get 3 choices, we get 3 releases, okay? And then what happens is the highest number starting from 1, the remaining 6 folks, individuals, those will, names will be called, you'll get the jury box. Then there'll be 1 alternative. And what will remain is 7 folks. I like to call the magnificent 7. The magnificent 7. But how do I decide? How do I decide who I want to use my release on, who I want to keep? I'm looking for 3 main things in a person. Number 1 is, are they a team-oriented person? Can they work together well with others? Number 2, A person that can follow the law and make decisions regardless of their bias or prejudice. A person that can follow the law regardless of their personal bias or personal prejudice. So what is a bias? A bias is something where it's like you tend to favor that thing. So if someone offers you a steak versus peanut butter and jelly, I like peanut butter and jelly sandwiches. I grew up on that. So I have a bias for peanut butter and jelly sandwiches. Okay. Now on the other hand, a prejudice is something that says, I had somebody that ate poppy seeds, they choked or nut allergy. I hate nuts. So even if I had to go with that, I would start before I ate them. That's a prejudice, okay? So I want to find people that can set aside their prejudice and their biases and choose fairly and apply the law fairly, regardless of those biases and prejudices, okay? And I want people that can faithfully execute the law as we try to find truth. So why do we have a jury? Why can't the judge just decide who's guilty, who's innocent? Why can't the defense attorney or the state decide who's guilty or innocent? Why don't we have a kingmaker? Well, the people that founded this country lived under the king. He was an oppressor. Okay? He was the judge, jury, and executioner. And they hated it. So what they did was they put it inside the Constitution that a person can only be found guilty only if 6 juries for misdemeanor, 6 jurors come together and have a unanimous verdict, a unanimous finding of guilt. Not 5, not 4, not 3, 6. So I like to call it a jury team. So only a jury team can find justice. And so what they did, they drafted that into the Constitution. And so today, justice again can only be found by members of our community, not people from Hardin County, not people from some other county, right here in Jefferson County. 6 people come together as a team. That is the only way that a person can be found guilty. Only way that we can find justice. So you all can see yourself as the jury team, the check and the safeguards on our constitutional rights. So who here has worked in a career where you have to work with other people to get something done? Okay, just not everybody. All right, Mel, we'll start here. And it's Joe. What do you do, and how do you work in a team dynamic?
I'm retired
Mm-hmm.
and I used to work for Walmart,
What did you do for?
claims supervisor.
Claim supervisor, okay. And so someone else, did you process the claim? Did you make the call to get the information, or where the information come from?
It's a misunderstanding. Claims means that I made a claim for products and got credit for it.
Okay.
Excuse me.
Okay, and did you have to work with other people in that process, or could you
Yes.
do it all by yourself?
I supervise people.
Okay, well, okay, so you were supervising, you worked with other people. So even if you were an all-star supervisor, but you had 1 or 2 people that just didn't know what they were doing, could you get the goal done and make those claims properly? If you were the all-star, but they didn't know what they were doing, could you get the job done?
Yes, we got it done.
You got it done, but did you have to work in the team to get that done?
We worked as a team.
If you didn't work in the team, could you get it done?
There were times I worked by myself,
Mm-hmm.
but if it's more than one person, we worked as a team.
Yes, ma'am. Got it done. Anyone else, third, number 4, John?
Yeah.
Yes, sir.
I work, instrument electrical, industrial construction, I'm a project manager, pre-construction specialist, those kind of things. It's all teamwork.
Okay, all teamwork. Pre-construction specialist, what is that like? What's the team dynamic like?
You have like, when you put together estimates for projects, you have some people working on power cables, some working on lighting, able to reach the different aspects of our project.
Okay,
They all come together.
and you come together to what end? What's the goal there? We all are coming together. What's the goal of the project?
Put in the best price we can, and cover the cost on it.
Yes, sir. All right. And if you're not coming together and working as a team, you got someone else to just say, hey, I'm not showing up, or I'm late, or I'm putting the information not correct on the into the report. Can you get the goal done or no?
Sometimes you have to, but yeah, it's definitely a lot harder if you don't have all the pieces.
Yes, sir. That's good. That's good. Third, Daniel? Yes, sir. Did you raise your hand earlier? Yes, I did. Tell me about yourself. Tell me, what do you do and how have you worked in a team situation?
Yeah, well, I'm currently job hunting,
Mhm.
so I'm doing right now. But the team aspect, was really when I was working for, Wells Fargo.
Mm-hmm. What you do for Wells Fargo?
I was a customer service representative for them as well as dealers, whenever they had the, I guess you call it license or the contract.
Mm-hmm.
That was about two years ago.
Okay. Happy honey on your search for employment. Anyone else over here worked in the team dynamic? Raise your hand earlier. Yes, ma'am.
Oh, I
Anyone?
did, in my, for 30 years, so. you know, The patient coding after birth is to
When you say coding, the patient is coding, what do you mean?
need CPR after the accident or something like that. You have to work as a team,
Yes, ma'am.
because you're saving lives. But if there's, 10 patients and you need one, and you need to scan the patients, sometimes you have to go get the patient yourself instead of waiting on somebody else to do whatever it is. But you have, in case of damage. That's so.
And so what happens if you don't work in the team in that environment?
The first one, critical,
Mhm.
thinking,
Like you got serious.
yes.
Ma'am. Ma'am. Someone on the back row, raise their hand, ma'am. Miss Christine? Yes, ma'am.
I'm a case manager.
Mhm.
I assist low-income individuals in becoming more self-sufficient by helping them with education, workforce training, coordinating services for them. I also facilitate a social services coalition where we work together to help bring services to, or make services more accessible to those in our community.
Hey, well, thank you for that. Thank you for your service. Very much needed. So moving forward, as it relates to sports, the dynamic is true in both our careers and also in sports. Who in here watches football? All right, all right. Baseball? All right. Basketball? Okay, all right. So what happens if you have an all-star, outstanding player on the court? He's just better than everybody else on his team and on the other team. But everybody on his team doesn't want to put in the work. Like, I don't feel like being there. I'm gonna take a day off. I see you shaking your head. No, can that team win with that all-star? Why not? Sure, that's it. You're overworking the one person. It's not possible for them to make the effort, no matter how much they put in, if they don't have the team working with them. So here is the same situation. Being a part of a jury is like being a part of a team. Takes everyone working together, find truth, hit the goal, find justice. Okay? Otherwise, we just left with ambiguity and we can't get to a final conclusion. We must find the truth and work together. So if you all are the jury team, the Magnificent Seven, I like to describe my role as much like a coach. And so my job here is to explain the law, teach the law that'll be applied today. We were working with terrorist threat. Explain the law to you so everybody understands the rules and the rules of what we're going to be working through today. And then secondly, my job is to provide you, when we go to trial, my job is to provide you with the evidence necessary for you to accomplish the goal in achieving justice as a jury team. Because only a jury team can do that conclusion. Only a jury team can find justice. My job is to explain the rules, and I'm going to do that today. My job is to provide you with evidence so that you can make a finding beyond a reasonable doubt. And so my coaching style is straightforward. Straightforward. I'm gonna tell you the truth. I'm gonna call a ball, a strike, and I'm gonna do everything that I can to get the truth out. Everything I can to get the truth out to you. Okay? So I'm gonna make you three promises right now. The first thing is that I won't put a person on that stand that I do not personally trust to tell the truth under this circumstance. Now, I'm saying anything outside the court, but on that stand, I'm not gonna put somebody on there that I believe is gonna intentionally sit there and lie to you. But guess what? If you take that stand, try to lie to you, I'm gonna do my best job to draw it out and expose it to you. They come on there and lie, whether it's my witness or anybody else's witness, the defense's witness, if anybody gets on there and tells the untruth, it is my job, my time to expose it. Anybody. Okay? And lastly, I'm confident by the time this is over, you'll have everything that you need to come together and find justice. So I promise you, I will give you everything that you need to make a determination and find justice comfortably as a jury team. So if you're the jury team, I myself, the coach, who's the judge? The judge is much like the referee. He's gonna call the balls and strikes. He's gonna say objection sustained, objection overruled. He's gonna, anytime, Mr. Lane and I are having something we're discussing about evidence or anything like that, we're gonna go before the judge, and the judge is gonna make those decisions, okay? So the judge is like the referee. So let's talk about the rules. I want to ask someone here who I haven't heard from. What happens if you don't follow the rules? Brian? Brian,
If you do not follow the rules,
if you do not follow the rules as it relates to your job or whatever it is that you're working on, what happens if you don't follow the rules?
get fired,
Get fired?
get, let go, released,
Okay. What do you do for work?
I have a landscaping company,
Okay. And at your landscaping company, you have employees there?
yes,
Okay, and if your landscaping employees are putting together rose garden or something like that, and they use the wrong kind of mulch or the wrong kind of soil for a particular flower, what happens if they don't follow the rules there and use the wrong type of thing? What happens to that work because of me?
no good,
No good.
you know, you need to follow directions, and, if they didn't do it, then, yeah. Want to find somebody else.
Yes, sir. Yes, sir. You remedy that problem. All right. And, okay. So I'm gonna read a statement and you tell me, whether you agree or disagree with the statement. If a person breaks the rules and nothing is done about it, a defendant is more likely to break the rules again. Who agrees with that statement? Who disagrees with that statement? Who disagrees with that statement? I'll read it again. If a person breaks the rules and nothing is done about it, a defendant is more likely to break the rules again. Who disagrees with that statement? Okay,
I mean, I think it's contextual where it could happen again. But I mean, it could be just like a one-time sort of case where it broke the rules because of whatever happened, and then the context, it happened there, but then once that's done, not gonna do it again. It's not, yes, but I don't think always.
okay. Is there anyone else who feels, against Tyler? Okay.
Yeah, 15 more minutes.
Thank you. Rick. Okay. Now, I want to make it clear. Mr. Simon is a United States citizen. He is innocent unless proven guilty. People say innocent until proven guilty, innocent unless proven guilty, unless a jury came together and finds him guilty. But now he's presumed to be innocent. However, he is alleged that he has broken the rule by making a terroristic threat. So what is a terroristic threat? A person commits a terroristic threat when they threaten someone with violence with the intent to place a person in fear of serious bodily injury. Okay? Notice what the rule is on. It's not whether the person who was threatened felt afraid. It's whether the person who made the threat intended for that person to be afraid. The person who made the threat intended for the other person to be afraid of serious bodily injury. Imminent serious bodily injury. Does anyone have any questions about that? I can clarify. Okay. So what the law doesn't require is to prove that the person who was threatened, it doesn't require that they be afraid. Next, imminent. Imminent doesn't mean immediately. Imminent, fear of imminent serious bodily injury means near at hand. It's close. Okay, it means immediate, not immediate. Okay, so it means the court said close but not touching. Okay, so imminent, fear of imminent serious bodily injury. The intent is on the person, you're judging the intent of the person who made the threat, not the person who was threatened. You understand? Any questions? Okay. Now, is there anyone in here who believes that if someone makes a conditional threat, do 10 push-ups or I'll shoot you? Is there anybody in here who believes a conditional threat is not a threat at all. Is there anyone who believes that a conditional threat saying, I made that threat only if they didn't do what I told them to do? That not, is anybody who believes that is not a threat? Because it's a future or condition. Yes, sir?
I don't think it is, because that person has a choice to either agree or do what they want to do or not. However, if somebody's asking you to put a pistol to your head and pull a trigger, I don't think you're getting a choice.
Yes, sir. So, is it Timothy?
Yes.
If it was, if you were presented the facts and you, in a trial, and you believe beyond reasonable doubt, if you believe beyond reasonable doubt that someone made a terrorist threat, based on the evidence, could you still follow the law and find the person guilty for the conditional threat?
I'm sorry, could you say that again?
I'm sorry. If you were presented evidence and you believe beyond a reasonable doubt that a terroristic threat had occurred, but it was based on a conditional threat, could you follow the law and find the defendant guilty, even though it was a conditional threat?
It's like the first statement that I said, it would have to be, you gotta understand, it's 20 years in the military. Okay? We got it ingrained in our brain, in our brains, you know, the example you gave earlier, are you gonna have to do push-ups? Okay, so our brains are programmed into that. I'm also a licensed counselor, and I counsel for people that have PTSD, which I myself do have. Okay, so I come from a military background that those kind of conditional threats are normal. Now, that's not to say that it's normal out here in the world, but it takes a whole lot for us to change the way our brains have been programmed.
I see. After a military experience, it takes time for you to change how you're responding to threats and other things. I see. So
Don't grab me by the leg when I'm asleep.
I understand.
Okay.
Yes, sir. Yes, sir. So, so just to drive, thank you for sharing. Just so we drive the point home, as far as intent, who the intent is on. The person making the threat is who you're gonna be analyzing. I'm gonna give you, few hypotheses. Who here watched Walker Texas Ranger back in the day? Okay, there's a series called Walker Texas Ranger, and there were these jokes, these Chuck Norris jokes that come out. So we're gonna talk about that. So here's a Chuck Norris. It says a mugger pulled a knife from Chuck Norris. Chuck Norris handed the man the second knife because he believed in a fair fight. Okay, all right. Another one. Chuck Norris was once threatened by a knife point. The knife has been a witness protection ever since. Chuck Norris doesn't get robbed. Chuck Norris gets approached by men who want to change in careers. Okay, so I said all that to say, no one here in this room believes that Chuck Norris was afraid, even though those people approached him with a knife or a gun and tried to murder him, right? Nobody believes that. But based on what you know now about the law, the people that came up to him, whether it's the knife or the murder, the robber, was that qualified? Do you believe in a terrorist attack? Based on what you know now. Okay. Based on what you know now. Yes? Anybody not think it was not a terrorist attack because Chuck Norris wasn't afraid? Is there anybody who thinks it was not a terrorist attack because Chuck Norris was? Right? So I'm gonna read a few statements here and just let me know if you agree or disagree. Now, Paul will go down with, generally speaking, if someone is, shot with a rifle, they will be seriously injured. Do you agree or disagree?
Agree.
Agree? Is there anybody who disagrees? Shot by a rifle, serious bodily injury. One who disagrees. Okay. I believe that threats of violence can be verbal and nonverbal. Agree or disagree? Okay. If a mailman comes on my property, I have a right to threaten him to leave. Okay, disagree? The mailman comes on my property, I have a right to threaten him to get off my property. Disagree? Okay, disagree? Anybody agree with that statement? Anyone agree with that statement? Okay. So we're gonna move on to, beyond a reasonable doubt, and defining that term, okay? What is beyond a reasonable doubt? Unfortunately, the law doesn't define what beyond a reasonable doubt means, okay? It does tell us that only by a unanimous jury team can justice be found, and someone be found guilty, but it doesn't define what beyond a reasonable doubt actually means. But, so that means I can't tell you what it means, but the good news is I can tell you what it looks like, and I can tell you what it feels like. What it looks like is a staircase, okay? On the bottom of the staircase, you have what's called a reasonable suspicion. That's what the cops need to go to look into a matter further, okay? Or do a traffic stop, reasonable suspicion. Next is probable cause. That's the standard, the next step that police need to make an arrest. That's probable cause. Next above that is called preponderance of the evidence. It's like a little bit hard, almost there, 51%, okay? Let's say using civil cases. The next level is clear and convincing evidence, okay? Clear and convincing evidence. That's the burden part to determine parental rights, clear and convincing evidence. And then at the top of that staircase is beyond a reasonable doubt, okay? Beyond a reasonable doubt. And at the very top is beyond all doubt, okay? The law requires us to meet a burden of beyond reasonable doubt. So that's what it looks like. What does beyond reasonable doubt feel like? What it feels like is driving through a four-way intersection, driving through a green line, when there are cars that could be coming crossways at you. So imagine yourself, you're driving through a green light, you look up, you see the lights green, you see the car stops on the cross sections, okay? And as you're driving through, you're not 100% sure that those cars are not gonna come through. But you feel confident good enough because you've done it before, you know your light's green, they've been stopped there, and you feel comfortable enough to drive through that green line. Not 1,000% sure, 1,000,000% sure. You don't, not 100% sure, because the drunk driver will always come through. But you're comfortable enough to do it because you've done it before. You know what your gut instinct feels like. And so today I'm gonna ask you to rely, and I present the facts, myself and Mr. G to present the facts in this case, to rely on your gut instinct, your experiences in life. The same thing you rely on when you drive comfortably through that green line. That's what beyond a reasonable doubt feels like. Now, you can't tell that the other people's lights are red because you can't see the face of them.
You have 4 more minutes.
Thank you. What that is, that's called, you're using those cars, the fact that the cars in the other lane are stopped. That, and you're drawing a conclusion, hey, those are red lights. Their light must be red. Mine is green, therefore theirs is red. That's using your intellect, your experience to draw an inference. You can't see it, but you can feel it. You know it because it's a familiar thing. That's the only logical possible conclusion. That's an inference, okay? That's circumstantial evidence. Direct evidence is if you get out of your car, you go look on the other side, you see the light's red, you saw it with your own 2 eyes, that's direct evidence.
If you need more time, we'll give it to you.
Thank you, Judge. I'm wrapping it up.
Okay.
So with that being said, ladies and gentlemen, I've got just a few more questions I want to ask real quick. Has anyone ever served on a jury before? Yes, ma'am. What kind of jury? And we'll come to you.
Civil
Civil?
and criminal.
Civil, what was the outcome of your criminal case? Was it guilty or not guilty?
It was not guilty.
Okay. Okay. And then Mr. Rowland?
Still, I did it from.
And what was the outcome of your criminal trial, the criminal trial? Okay. Okay. And then anyone else served on a jury before you, sir?
Civil.
Civil, and rule in favor of the plaintiff or the defendant? Okay. Anyone else? Yes, sir.
It was a criminal case.
Okay. And was it guilty or not guilty?
It was dismissed because the second day when they went to show evidence on the screen. They had also had a picture of the, criminal's former record, so they had to drop it.
Understood. Anyone else over here? Yes, ma'am?
Criminal and guilty.
Helen? Thank you. And we have one more in the back. Yes, sir. So. Okay. Plaintiff, who in favor of the plaintiff or defendant? Okay, and then let's first thing.
Criminal.
Okay. Guilty or not guilty?
Guilty.
Okay. Anyone else? Okay. All right, and once again, ladies and gentlemen, I thank you so much for your time. I enjoyed speaking truth with you, and I'm looking forward to meeting the magnificent seven. Thank you.
Okay. Mr. Lyon?
Good afternoon, again, my name is Kevin Lane, I'm born and raised in Beaumont, I've got to assign here. We're gonna be trying a misdemeanor case, it's a class B misdemeanor that carries up to 180 days in county jail. We each had 3 peremptory challenges. 3 strikes for the state, 3 strikes for the defense, and the first 6 that are left over will be our jury and sworn in. I believe the court is gonna want an alternative. This case is about bad blood between 2 neighbors. And lots of back and forth between the fence that divided 2 neighbors. And then it came to a head. We're going to argue and we're going to prove to you that there was a temporary electric pole on Mr. Simon's piece of property that his neighbor wanted access to. But she didn't want to do it in the right way. And she used the system to go onto his property illegally. Now, when in Texas, we're at our house, we're presumed to protect ourselves, our personal selves and our family members. We're not protecting property when we're at our house. That's our castle. So if we do things there and we present force or something like that, or threats, we're protecting ourselves and not our property. So with that in mind, I want to see how you guys would think about a set of facts when you have a situation like that. What the state of Texas has to prove beyond a reasonable doubt, that means the 6 of you that are sworn in as a jury. Yes, you will sound as a collective group, whether they're not guilty, Mr. Simon is not guilty or guilty, but it's your individual judgment that the state of Texas and the Constitution of the United States requires. You vote individually. If you find yourself and you're saying that person is guilty and the other 5 are saying, well, I think he's not guilty, or the state did not prove that he intended beyond a reasonable doubt to threaten the complaining witness with serious imminent bodily injury. That he intended, not that she feared it, not that she felt it, not anything having to do with her state of mind, but that he did. And they must prove that beyond a reasonable doubt. Say, well, I think he's guilty of it. And the other 5 are saying, no, I just don't, they're not getting me over that point. He's at his house, he's protecting himself, his family members and all that. Well, would you simply just change your vote and go with the not guilty folks? Would you require those 5 persons to say, well, look, convince me to prove guilty? Or would you go or not go? Or vice versa? If you're the one that says not guilty, no, I think I'm protecting myself, and I can show up at my door with a firearm and say, get off my property. And would you in that case say, well, I'm going to allow citizens of the United States to do that, especially when there is bad blood and there is previous force. Okay, and you're going to hear some evidence about how that bad blood is and what state of mind that Mr. Simon was in, and you might hear some of that from the complaining witness who was the name about what her state of mind. So once again, yes, you are a team, but you will act individually based on what you think the facts show beyond a reason. You can believe everything that a witness says, some of what a witness says, or nothing of what a witness. Now, by a show of hands, who owns a gun? Okay, I'm gonna go to you, Mr. Wonder. And you yourself, you said you were in the military, were you not?
Yes,
Okay, and you have a gun in your house, I presume?
yes.
Okay. When would you ever show somebody that might be on your property your gun? What situation?
And they present themselves to breach my household.
Okay. Well, in what way? Say you have a gate, you have a driveway, and they come up and pass your port of entry and then go onto your property. Is that some situation where you may say, hey, guys, what are y'all doing on my property? Get off my property. Is that a fair situation?
Well, I was trained to say that I did not shoot somebody to kill them. I shot to stop. Reason why I say that is this. Somebody comes in and tries to get inside my house. I know that legally, once they stepped inside my house, I have the right to shoot.
Okay. And then in that scenario, you of course are protecting yourself. Where are you gonna run? You can't run anywhere but your house, correct?
That's right.
Okay. So, well, let me ask you this. If you're showing force with a gun, the person that's on your property, and you say, get off of my property, and they don't go and they ignore you, what do you do then?
So,
Call the police. Anybody here disagree with that? By a show of hands? Mr. King, you were once a DPS officer, were you not?
yes, sir.
Okay. And as a DPS officer, you had a loaded firearm with you at all times, did you not?
Yes.
Was there a difference between unholstering your weapon and say pointing it down, as opposed to unholstering your weapon and in a felony takedown situation? Is there a difference? Not pointing your gun at somebody and then pointing your gun at somebody?
Perceived threat.
Okay, perceived threat. And in what instance would you do a felony takedown with your gun pointed at the person, maybe they were running in a car and y'all were chasing? And then that situation versus when you may have unholstered your firearm and not pointed it. Can you think of two different instances?
Bolstered it, I was probably pointing at him.
Okay, so you have you ever said, if you don't stop, I'm gonna tase you. If you don't stop, I'm gonna tase you.
We didn't have to.
Back then, okay. Well, and that's the point I'm making. Well, say you're dispatched to a home and for disturbance, maybe family violence. I don't know if you did that in DPS, I'm sure. Okay. Well, in law enforcement, if you were to go on somebody else's property and you're not in pursuit, in high-speed pursuit of this person who's going onto a piece of property, what do you do when you go onto somebody else's property? Do you just go onto that piece of property, or do you go and knock and announce your presence? Have you ever done that?
Why would I be on that piece of property?
Right. If you were on somebody's piece of property, would you just go on that piece of property and go all around it, or would you announce your presence, knock on the door, anybody here, anything like that?
On that, why I would be going on that property?
Okay, well, just say that you were going on just to take a look at items on the property. I say a utility pole.
Announce.
You would announce. Would you go to the front door and say, hey, I'm Officer King, I'm here and I'm looking around something on your property? You would. Because you wouldn't want the homeowners there to be frightened of who you are. You want to know who you are.
Right.
Now, you probably would have had some distinct uniform on, and a hat, and then they would have said, this is on, correct?
Right.
Okay. You wouldn't just kind of scurry onto somebody's property and just start looking around.
No.
Now, I see, I believe it's Miss Jackson and I think, Miss Kurt. Y'all seem to both be correctional officers. Y'all know one another by chance? Okay, well, but that is a law enforcement, position that you're in a way, is it not? And I'm not sure, you guys probably don't have a sidearm in jail, do you not? Okay. Do you carry tasers or anything like that? Okay. Well, I guess since I'm not seeing, if you're going in somebody else's cell, they actually call them houses, do they not? That's kind of, where they have a reasonable expectation of privacy in the cell, do they not? Right, unless there's some contraband, or you may have gotten some word from somebody else that they have contraband, or they won't come out after you've knocked and announced, but you would go up and knock and announce, we're coming in, Mr. Jones. Step aside, we're gonna search, right? Okay.
I'm on STG, CIT, so.
Okay. The point I'm trying to make is knocking and announcing your presence on somebody's house or their residence is probably the best ordeal, is it not? It's the best way to go about it. I want to get back to, some other folks that have guns in their homes. Can I get another raise of hands on that? I didn't see that. Okay, we gotta pick on you, Ms. Phillips. When's the situation you might show a firearm when you're at your house, if you can think of it?
If someone's trying to break in.
Okay, do they have to physically come up? Maybe you're scratching on your window or something like that?
No, I would show, if I had someone do that, I would probably show them my weapon.
Okay. What if there were two people you didn't know and they were in your yard and you told them to leave? Would that be, I'm going to get my gun? Would you do that?
It doesn't apply to me, I live in an apartment, so it would have to actually be a break-in before I would, show them my weapon, and or if they were persistent in knocking and I asked them to leave,
Okay.
then I would just announce that I'm armed.
Well, let me ask you this. What if you had some bad blood with your neighbor and your neighbor was sitting there consistently knocking and saying, well, I'm coming in to check it out. You have a piece of property in mind. What about them?
I would announce I'm armed.
Anybody disagree with that scenario? Ms. Sells? You have a firearm at your house, do you not? Can you think of a situation when you might show a firearm?
So,
Okay. What if they're in your yard and don't appear to be breaking in, but they're just in your yard?
the area I live in, you know, most people, so I'd probably just go talk to them, have a conversation.
Okay. What if there's bad blood and they've been in the yard before and they haven't gotten out before?
They won't get out, I'll call the cops.
Everybody agree with that? Show of hands. Some more people that have guns in their homes. I'm sorry. Miss Wade?
Yeah.
And when's the situation you might say, look, I got a gun, get out of my yard?
Yeah, feel great.
Okay. Okay. What about on the back road? Ms. Jackson, do you have a firearm at your house?
No.
No? Anybody else? Mr. Jenkins? Oh, yeah, okay. Mr. Lytle?
Yes.
When would you show your firearm?
If I intend to shoot.
Okay, and only intending to shoot?
Yeah.
Okay. What if you had bad blood, they've been on your property before, you see them driving and stopping at your house and cussing you out every day? And then you go and they're there and you're the back of your house and you say, get out of my house, get off my property, and then they don't leave. Would that be?
I called out.
Okay, you go back in, lock the door, call the police. Does anybody else, have the same feelings as Mr. Lyon?
I don't have guns, but I would say similar sort of idea.
Okay, Pastor, you would say, get off my property. If they didn't, you would go back in, lock the door and wait for the police.
Yeah, I don't,
Okay. Anybody else feel that way? Let me ask you, do y'all remember there was something up north where there was a gated community and I think there were a bunch of protesters who were coming in front of somebody's house because they had kind of knocked down the gate. Y'all remember that? And there was a plaintiff's attorney that came out and got on his porch with a firearm. Anybody remember that? Mr. Marty, you shaking your head. What do you remember about that?
just as you, I mean, just as you described it, I didn't know it was a gated community, we paid that much attention to it.
What did you think about that? Was he allowed to do that, you think?
It may have been a little overboard. for me,
Okay.
But there again, I don't know the whole scenario of it.
Should he go to jail for 180 days?
There again,
He didn't.
didn't know the whole scenario.
Do you know what happened to him, Ms. Delon?
There wasn't any further discussion about it. I believe, was someone shot? It was an AR-15, it wasn't like. It was
Frankly, I don't remember. I think,
It was an automatic.
yes.
So it was insane, I think, but
Okay, you believe it was an overreaction on his part?
absolutely.
Okay. And Mr. Marty, you believe that?
I mean, there again, not knowing the whole evidence. If it's just a group of people walking down the street, then that's one thing, and then, you know.
Yeah, 15 more
It was
minutes.
a gated community, I don't know.
Anybody else feel that way? Mr. Wimmer? Wimmer.
I think that it depends on the situation. We were trained in the military. You meet the level of force at the level that they're out and not at the level above. Somebody comes at me with a knife. And of course, I have a pistol, then they're bringing a knife.
Right, exactly. Bring a fist to a fist fight, a knife to a knife fight, a gun to
So
a
if
gun fight.
those protesters were physically beating other people up and they had a bat or whatever, and they're at my door, then I might warn them that they need to get off my property.
What if that person's son had shot and killed your uncle on that property? What if that person that was on your property's son shot and killed your uncle on that piece of property? Would that change your answer?
Would that change my answer? No, it wouldn't, because I'm not going to jail for somebody else's stupidity.
The question being there is that sometimes, yes, fist to a fist fight, knife to a knife fight. Unless it has in the past escalated to a gunfight that resulted in murder and conviction. Anybody else have the same feelings as far as the best circumstances if somebody's on your property? Just go back in your property, mind your own business, lock the door and call the police and wait for the police. Is that the right thing to do? Ms. Sales? You believe that's the right thing to do? Okay. Ms. Phillips?
Yes.
Okay. I'm sorry. Anybody else? Pastor, I got anybody else on your side? So the best thing to do at your own house, if somebody's on your property, is to go back in, even if you got some bad blood. And I know it's a trick question. It depends. And if you call the police before and the police don't come out, and they never do anything. So anyway, we have an honest dispute and we're going to present our witnesses to you that saw the entire thing. Mr. Simon's going to tell you what happened. And you will decide whether or not the state proves beyond a reasonable doubt that he intended to threaten them with imminent bodily injury by his action. We ask that you listen to all the evidence, wait until the defense puts on their witnesses before you make a decision. Once again, I thank you very much for your service, and this is the best system we have in the world. Thank you.
Okay. Okay, ladies and gentlemen, at this time, we're gonna ask that you step out into the hallway and you can go out either one of the two doors, and we may have to call some of you back in for some follow-up questions. So at this time, you can exit the courtroom. No, they're not yours. You may be seated. Jefferson County Court at Law number 2 is back in session. The court is in session and calls number 25 CCCR 1758. The case is styled the state of Texas versus Joshua Dwayne Simon. Let the record reflect that Mr. Simon is present in court with his attorney, Attorney Kevin Lane. Let the record reflect that the state is present with Assistant Criminal District Attorneys, Attorney Fred Vernon, Attorney Nicholas Jeter, and Attorney Andrew Hubel. Let the record also reflect that the panel is now seated and present in the courtroom. Ladies and gentlemen of the panel, our court administrator, Ms. Brilla Balkay, is going to call some names. If your name is called, please walk up to the jury box. There are some tags on top of the counter. Take one of the tags and pin it to your clothing and have a seat in any one of the chairs in the jury box. Ms. Balkay, you may proceed.
Joe Phillips.
Joe Phillips, please.
Larissa Sales.
Larissa Sales.
Roland Dooms.
Mr. Dooms, you can take a tag and have a seat.
Daniel Mays.
Daniel Mays.
Kirsten Kirk.
Kirsten Kirk.
Helen Wade.
Helen Wade.
Christine Jackson.
Christine Jackson. Okay. Members of the jury, I will give you some instructions and a general idea of what to expect in this case. Every case is composed of facts and the law as it applies to the particular case. The facts come from the witnesses on the witness stand. The law comes from the statutes, codes, rules, and court decisions interpreting them and how they may apply to this case. You and I have equal authority, but it is divided authority. You are the sole judges of the facts, and I'm the sole judge of the law. You are the sole judges of the credibility of the witnesses and the weight to be given their testimony. You can believe all of what a witness says, part of what a witness says, or none of what a witness says. As the trial progresses, the attorneys will probably make objections to questions asked by the other attorney of witnesses, or objections to the introduction of documents or objects. This means that in the objecting attorney's opinion, there is a legal reason why the testimony or document or object should not be received by you. Sometimes I will simply sustain or overrule the objection. At other times, it may require a lengthy discussion outside of your presence. If that happens, I will either ask you to step outside for a few minutes or ask the attorneys to come up to the bench so that you can't hear the discussion on the point of law. The reason for this, as I told you earlier, you are the sole judges of the facts you receive, and I'm the sole judge of the law. I can't be with you in the jury room when you deliberate the facts. Therefore, you can't be present or within the hearing when I deliberate questions of law. The reason why I will sometimes ask you to step outside is because it is simply the most efficient way to do it. Otherwise, if we were to leave the courtroom, the court reporter would have to gather his equipment and take it with him, and the attorneys would have to gather their files, etc. Rulings I do make on questions of law in your presence are not evidence, and you are to disregard them. After all the evidence is in, and both the state and the defendant have rested their cases, the court will prepare and submit to you a written charge instructing you on the law in this case. We will then hear oral arguments from the attorneys. The attorneys have the right to make a summation of the evidence and to make reasonable deductions from the evidence. Since the state has the burden of proof, it has the right to open and close the summation or argument until you retire to deliberate. Do not discuss this case amongst yourselves, and under no circumstances should you permit anyone to discuss the case with you. Do not attempt to learn from any source outside of the courtroom anything about the facts of the case, nor attempt any independent investigation on your own. Don't visit the scene of the involved in the facts of this case. Don't read any reports in the newspaper, on social media, or watch TV reports about the case. Don't make up your mind about this case until all the evidence is in and you have been instructed on the law. Don't take notes during the progress of the trial. Don't visit other courts during a break if a trial or other proceeding is in progress. The badge that you have, please wear that badge at all times while you're in the courthouse because it identifies you as a juror in this case. Now, ladies and gentlemen of the panel, those of you who were not selected to serve as a juror in this case, first of all, I'd like to thank you for being here this afternoon. I know some of you may be disappointed because you were not selected to serve as a juror in this case. Some of you may think that you just came down here and wasted your time. But I can assure you, you did not waste your time. And the reason why I say you did not waste your time is because, as I mentioned to you earlier, this court had 3 dockets this morning. One of those dockets was a trial docket. One was a announcement docket, and the last docket was a pretrial conference docket. Before you came here today, all those individuals' cases that were on the trial docket, they had attorneys negotiated, they were provided offers by the state, and now we're here today. Some individuals put their case on the trial docket because they believe one of two things is going to happen. One, they believe that maybe a jury is not going to show up, or maybe they'll believe that witnesses are not going to show up. But on days like today, when witnesses show up and when jurors show up, some individuals have a change of heart. They say to themselves, you know, the offer that the state made to me a few months ago, it looks pretty good right now. And it's because of people like you who showed up to serve as jurors in this case. So you did not waste your time, because the way our system is built, your presence helped courts to move cases. And so we would like to thank you for your time and your attention. And I like to say that anytime that you're in the area of County Court at Law number 2, you can come and have a seat in your courtroom. Now, the reason why I said it's your courtroom, I know when you came here this afternoon, you probably looked over the top of the door and you saw County Court at Law number 2, Judge Terrence L. Holmes, and you may have said to yourself, you know, I'm in the right place. I'm in Judge Holmes' court. Well, this is not my court. This court is for the citizens of Jefferson County. You are the citizens of Jefferson County. So I've said that to say this. Anytime that you're in the area of County Court at Law number 2, you can come and have a seat in your courtroom. In fact, you can sit in that area that you're sitting in. We call it the peanut gallery. But it doesn't mean you can bring peanuts in here and eat, because this is not the Texas Roadhouse. But you can come and have a seat in your courtroom, and I can assure you that you will find it to be very interesting. Now, your services are concluded. Our bailiff, she has some letters that she's going to give you. And once you get those letters, you'll be free to go. And each and every one of you have a blessed day. And before you leave, I like to give each and every one of you what I consider an air handshake. And so, you know, we still have COVID in our community, but I like to give you an air handshake. So thanks for coming down here. If you would like to watch the trial, I think we're going to start back up tomorrow.
Yes, sir.
At 1:30. You could be here in person, or you can watch us on YouTube, whichever is convenient for you. So at this time, you're free to go, and each and every one of you have a blessed day. You are. Okay, ladies and gentlemen of the jury, on tomorrow, we will start over. We're going to start the testimony in this trial. And just to give you a little idea of what to expect on tomorrow, the state is going to read the information. Now, I know people are familiar with the term indictment, okay? Indictments is for district court. It's a charging instrument. The charging instrument in a misdemeanor court is called an information. It's still a charging instrument. You know, it basically states what the person is charged with. And the state is going to read the charge, and the defense is going to enter their plea to the charge. And then once we finish with the charge, we will have opening statements. The state can make an opening statement. The defense has the right to make an opening statement, or they can reserve their opening statements. They don't have to make it right behind the state. And then after opening statements, we will have our witnesses that will start. The state will call their first witness, and then the trial will proceed from there on. Now, we ask that each and every one of you be back here in front of the courtroom like you were today at 1:30. Hopefully we will start promptly at 1:30. And once we start promptly at 1:30, we usually have breaks in between. Okay, I don't know how many witnesses the state are, I don't know how many witnesses will be testifying. Okay, so at this time, the court will be in recess. At this time, you can exit the courtroom, and we'll see you back tomorrow at 1:30. Okay? Y'all can keep your badges and keep your badges and bring your badges with you. Okay, make sure you wear your badges when you come to the courthouse. And thanks for reminding me. You got that one. Court will be in recess till 1:30 on tomorrow. You're welcome.